Hello and welcome to this edition of Let's Talk Law. I'm Anusha Soni. Today we discuss the Krishna Janmabhoomi dispute. A district court in Mathura has ordered the survey of the Shahi Idgah Mosque by the Revenue Department. A status report after the survey has to be submitted. Senior Civil Judge Sonika Verma directed the Revenue Department official to inspect the premises and then file a report along with a map. The direction of the district court has come in on a plea filed by the Hindu Sena in the name of the deity, Bal Krishna. On the other side is the Intezamia Committee, which manages the Idgah. Vishnu Gupta, the founder of the Hindu Sena, is representing the Hindu side in the case. And this is not the only case, as you'd be aware. At least a dozen cases have been filed in courts of Mathura by different people seeking the same thing. All these Hindu petitioners argue that the mosque should be removed from the 13.77 acre area. But this latest development and the order pertaining to the survey of the mosque is an important turning point in the Krishna Janmabhoomi dispute and this case. This dispute has a different kind of a background and a history to it. Unlike the erstwhile Ayodhya dispute or the present-day Kashi dispute, in this case, in the case of Krishna Janmabhoomi and Shahi Idgah, there is actually an agreement that was reached between the two sides. The Shahi Idgah Trust, which is the mosque committee, and the Shri Krishna Janmasthan Seva Sangh. The agreement of 1968 had apparently settled this dispute, as both sides had given up claims to certain disputed areas. But interestingly, in this latest petition, the very legality of this agreement has been challenged at the district court. The Hindu petitioners argue that the signatories of this agreement on the Hindu sides were not the true representatives of the deity, and hence the agreement is illegal. The Shahi Idgah Mosque that stands right next to the Mathura temple will now be inspected. There are strong voices from the Muslim community that have opposed this inspection. There are allegations that old wounds are being festered to create communal disharmony in the country. Now, where does the law stand on matters like these? Because one after another, various such litigations, such disputes are knocking at the gates of the judiciary. Let's break it down and zoom out a bit to understand the broader complex issue. The destruction of the Hindu temples at the hands of the Islamized foreign invaders continued for more than 1100 years, from the middle of the 7th century to the end of the 18th century. Various historical accounts, ASI reports, other academic research would substantiate this argument. This destruction that happened from the north of our country to the south is a reality that we have to acknowledge in our earnest attempt to understand this issue. India got independence, and post-1947, a new political era dawned in India. We became a democracy. In all these years, in modern democratic India, there has been no attempt that has been made to settle the old historical disputes, and they have been merely shoved under the carpet. Well, that's the larger context and the historical background of these disputes. Instead of addressing the large-scale destruction of Hindu sites and temples, perhaps considering the communal flare-ups that was a concern at one point in time, an act like the Places of Worship Act 1991 was passed. This act or law sets a cut-off date. The cut-off date is 1947, which means that the religious character of any place of worship cannot be altered as it stood in 1947, which means a temple remains a temple and a mosque remains a mosque. It is argued that this particular act, the 1991 law, ignored the historical reality that many mosques actually stood at the Hindu temple. The Hindus believe that this was a raw deal, and the very constitutionality of the 1991 Act has been challenged at the Supreme Court of India. But it continues to remain the law of the land till struck down by the courts or by legislative intervention. So with the historical background of temple destruction and the legal position that nothing can be reclaimed, a breeding ground has been created for such disputes with no avenue other than recourse to courts. Let's come back to the Krishna Janmabhoomi dispute now. It seems that the Hindu side has now raised a completely different argument to remove the hurdle of the 1991 Act. Well, here's something interesting. In the Krishna Janmabhoomi title dispute case, the district court has said that the 1991 Act actually does not apply. How does that work? The Hindu petitioners argue that the 1991 Act does not bar the authorities from ascertaining the religious character of a place Hence, a survey must be carried out. We'll talk more about the religious character. But if a mosque has existed in a certain place for 100 or 200 years, what can be surveyed? Even if a deity is found, how does that really help the case? The answer lies in understanding that Hindu deity or gods have property rights under Indian law. And once the existence of a deity can be proven, then nothing can vitiate the property rights of the deity, not even an agreement like in the case of Mathura dispute. As I said, under the Indian law, the Hindu deity has property rights and is recognized as a juristic person. So, for example, Ram Lalla Virajman in the erstwhile Ayodhya dispute was represented by his friend Devaki Nandan Agarwal at the court when this dispute was being heard at different courts in the country. Lord Krishna is represented by some friends at the court right now, citing that they are representatives of the god and the deity and hence they are suing on behalf of the deity. So while a deity has the right to property, a deity exercises his rights through someone else. That's exactly what's happening in these disputes. Let me simplify this further. If it can be proved that a deity or an idol resides at a particular complex, then arguably the religious character of that particular place, despite the performance of namaz or any other religious activity, it can be claimed, it can be argued that the religious character of that particular place was Hindu and unaltered, and hence it is not covered under the 1991 Act. That's broadly the line of argument and the approach adopted by the Hindu side in the Kashi dispute and in the Mathura dispute as well. Hence, one after another, surveys are being sought and litigations are piling up. It would not be a hyperbole to argue that many such disputes around hundreds of temples will knock the gates of judiciary in the times to come, despite the existence of Places of Worship Act 1991. The issue is emotive and legal at the same time. To dismiss the case pertaining to the reclamation of Hindu sites, for example the Kashi dispute or the Mathura dispute, as mere emotive or sentimental issues would be to deny and dismiss the history of invasion and destruction. Law cannot be blind to this historical reality. In fact, Indian Constitution has taken upon itself to address historical injustices through reform in special laws. But the erstwhile Ayodhya dispute tells us that to hope for any kind of compromise, mediation or settlement is a utopian idea. With no sight of a political solution or an amicable resolution between the two sides, a complex legal battle that can prolong for decades seems to be in the making. And that's perhaps the fate of all these disputes that you're seeing play out in the courts for now. Thanks for watching.